I'm told that my job here is, fortunately for you, just to keep to be the pretty face that keeps these people on time and occasionally make a pithy remark. So here's the pithy remark. This discussion, and I'm sure like you who were here last night or have heard all these discussions this morning, is on speaking for me, I'm sure you share this, I'm blown away at the high level and the deep thought that has gone into all of these presentations. I just want to say to you that for people like me who live on the ground, not barely crawling under it, that these decisions confront us every day. Every day, whether it's for the Ontario Labour Relations Board, whether it's in an appeal of the Employment Standards Act, whether it's in a certification application, or whether it's in a reprisal complaint, these decisions about whether somebody's an employee, an independent contractor, whether this person belongs in a bargaining unit, what makes sense, even under the existing outmoded and desperately crying out for a reform system. These things affect people every day in real hard decisions. And with that, you're going to have the chance to see a little team of superstars here espouse much more clearly or articulately than I could on that. So let me quickly introduce the people to you. Sitting to my immediate left, and there will be people in the audience who think that is a space metaphysically impossible to exist, but is Sandra Sperino. And Sandra is the Associate Dean of Faculty and Professor of Law at the University of Cincinnati College of Law. I always like to know things like this. In 2017, she received the Goldman Prize for Excellence in Teaching, which is not something that I recall fondly from my law school days. She's the author of several books, one of which is on sale outside, about unequal, how America's courts undermine discrimination law. She has been published at the Harvard, Stanford, Yale Faculty Forum, the Michigan Law Review, the University of Illinois Law Review, the George Mason Law Review, the Notre Dame Law Review, far better places than I've ever been published. Prior to joining the University of Cincinnati law faculty, she served on the faculty of the Temple University Beasley School of Law and was a visiting professor at the University of Illinois College of Law, from which she holds her JD, and the St. Louis University School of Law. And like all good academics in the United States, she clerked for a district court judge, the Honorable Donald J. Stora of the U.S. District Court, the Eastern District of Missouri, a place I've never had the pleasure of visiting. And beside her is Andy Sims. It's hard to imagine that there's anybody in the room who needs to be introduced to Andy, but Andy, between 1985 and 1994, was the full-time chair of the Alberta Labour Relations Board, and during which 1992 he took the responsibilities of being the chair of the Alberta Public Service Employees Relations Board. He then spent another over 20 years as a part-time vice chair of the Alberta Relations Board, and he did that as well with the Canada Industrial Relations Board. In addition to not being busy enough doing that, he, in 1996, was the chair of a task force that people refer to still now about amendments to the Canada Labour Code called Seeking a Balance. He's been a member of the Alberta Law Reform Institute. He's taught at the University of Alberta Law School. He's been involved in organizations like the Canadian Institute for Administration of Justice, the Council of Canadian Administrative Tribunals, and he did a review for the Alberta Compensation Act for appeals in 1994. And like if he didn't want to retire then, and between 2000 and 2017, he's done for the Alberta government 4 reviews, the Construction Labor Relations Review, changes after the Saskatchewan Federation of Labor case, since even in Alberta they perceived that perhaps some of the statutes were in constitutional jeopardy, and he has rewritten the post-secondary institution stuff, and they have just enacted changes to the Alberta Labor Court. The only thing is that Andy will talk longer than this introduction. And besides Andy is Fay Faraday. Fay Faraday has represented unions, community organizations in many of the important leading constitutional and labor and human rights cases before the Supreme Court. She's a co-chair of the Equal Pay Coalition in Ontario. She is an innovation fellow with the Metcalf Foundation, which I didn't know about, which addresses the rights of migrant workers. She's a visiting prof at the Osgoode Hall School. She holds the visiting chair in social justice and social justice at York University. The Packer chair, excuse me. So I'm going to turn it over to them in reverse order. Fay's going to speak about broader-based bargaining for female-dominated work. Andy, because I have to get him to give me this pithy title for what he's going to talk about, is going to talk about an engineer's view of the fissuring of the Wagner model. It really fits in there. And you're going to start talking about U.S. inadequacies in the discrimination law.
So thank you so much for having me here today. The conference has been lovely. I think as an American, I may have learned more than anyone else in this room. So you've greatly expanded my knowledge of Canadian law and given me a lot to think about in my own work. So I know it's after lunch today, so I'm going to have a little bit of an interactive presentation. I'm going to do an introduction, and then there'll be a quiz. But don't worry, there aren't any grades that are going to be assigned. So I have about 15 to 17 minutes or so, I've been told. And in that 15 to 17 minutes, what I would like to do is really to combine 3 topics. I'd like to talk about Harvey Weinstein, the precariousness of workers, and American employment law. And so we'll see if I can do that in 15 to 17 minutes. So if you are an American employment discrimination scholar like I am, your phone has been ringing off the hook with questions about Harvey Weinstein. And so I want to give you a hypothetical, roughly based on the allegations, and then show you how American employment law is not able to handle this adequately. And so imagine that we have a worker, and maybe we have many workers, and they're in different relationships to a potential employer. Some are seeking work, some are seeking to be an independent contractor, some may be working already but hoping for other projects. And in these roles, and let's just imagine it's a woman, although it could also be a man, we have someone in a high level of power who does one of 2 things. They either grope them repeatedly or they place them in uncomfortable situations where there are solicitations for sexual favors, but there's resistance and those are not carried out. So the calls that I've been getting sort of assume that if the person were to file a complaint, that the American legal system would provide redress. And so I'm here today to tell you that unfortunately the answer is no, likely no, and for a couple of different reasons. So if we think about the American legal system, we have a system that's slightly different than your own. We start with the foundational concept of at-will employment. And so as you all know, at-will employment basically makes an assumption that the employer can control many aspects of the workplace, wages, hours, terms and conditions of the work, unless some other source of law or a contract provides to the contrary. And so if you're facing a question of employment law in the United States, you start with at-will and then you try to find a positive source of law that might provide a worker protection. And since we have a federal system, both federal and state law might govern any particular employment question. And so if we're asking the question about whether these actions that have been taken violate the law, we have to look at state statutes, we have to look at state common law, we have to look at federal statutes, and we also have to look at contracts to find the answer. Now I want to focus our attention today on federal law, and as many people have discussed today, it seems like this is happening in Canada as well. We still have a very Mad Men era sort of view of the workplace, right? So our workplace laws were established when people actually went to a physical workplace. They went to that physical workplace for a set number of hours per day. There was an anticipation that people would work for one particular employer, maybe for their entire working life, but at least for a period of years. And what we've heard today is that that model no longer holds true for many workers. And so the U.S. law, like the Canadian law, has not quite caught up with today's realities. And so if we look at the three primary protections at the federal level, we have Title VII, which was the initial federal employment discrimination statute enacted in 1964. And this statute prohibits employment discrimination on the basis of race, sex, national origin, religion, and color. 3 years later, in 1967, we had age discrimination protections. These are actually added by a separate statute called the ADEA. And then not until 1990 did we have disability protections. So even though these statutes are written with extraordinarily broad language, if you actually look at the text of the statutes, the language of itself is quite capacious. We've seen the courts over a period of time through the case law actually draw back on many of the protections that are seemingly offered. And what's strange for those of you who do comparative law is you can't actually just read the U.S. Supreme Court cases and have a good understanding of what's going on in American law. And the reason that you can't is that the Supreme Court has often stated time after time that each of these statutes is very broad, is meant to provide broad protections, but the appellate courts have not always bought into that same vision. And so because we have a three-tiered system, most cases don't make it to the Supreme Court of the United States. And so justice for many people is decided at the federal level, at the federal trial court, or maybe at the appeals court. And so what Suja and I did for our book Unequal, we and a set of very depressed research assistants, is we looked at what happened at cases at these lower levels. So what was happening in the reported cases at the trial court level, what was happening at the appellate court level. And we read thousands of cases, and in our book we tell the stories of many of the cases. So in a second I'm going to give you some hypotheticals, but they're not hypotheticals at all. These are the actual cases of real workers. Often we are using the description of the evidence that the court itself is using in its written motion, so we have not re-described the evidence in any way. Now on the Harvey Weinstein question, we sort of have two questions. So the first is whether the federal employment discrimination laws would provide protection. And there we're going to have to know a lot more about the worker and where they were in the employment process. So the federal statutes, unfortunately, don't protect independent contractors. They often don't protect many who are applying for employment if we define employment in a very broad sense. So if you are just seeking potential work down the line and not an actual concrete job that actually exists, you may not be protected under the federal employment statute. So in our situation, we actually have to have someone who's applying for an actual job or a current employee, and we mean that in the traditional employer-employee relationship, in order to even come within these protections. But even once we come within the protections, don't think that these broadly worded statutes necessarily offer any help or remedy for workers. Okay, so I'm going to give you a hypothetical, and then just so that everyone will be honest, I'm going to actually ask you to close your eyes, everyone, and then we're going to have a vote on whether you think this is discrimination. So Tammy's supervisor, Bob, accidentally copies her on an email. In the email, Bob says he's never going to give a good work evaluation to African American workers. Tammy, who is black, receives a bad evaluation from Bob, even though she does good work. Is it possible that Bob has discriminated against Tammy? Okay, so close your eyes and then raise your hand. How many people say yes, that's possible? All right, how many say no? Okay, so let's go to another one. Stan is 62. I'm going to cover all of my protected classes, or many of them. So Stan is 62. His younger supervisor tells him, "You are too old," then this is a quote, "You are too old to do this job." 2 weeks later, the supervisor fires Stan. Is it possible that Stan's supervisor took age into account? I say, close your eyes. Okay, yes. Okay, hands down, no. Okay, one more. Ron is best supervisor. He asks her out on date multiple times and she refuses. He repeatedly asks her questions about her personal life, massages her shoulders on multiple occasions, places "I love you" signs at her desk, and tries to kiss her 3 times, and I'll just note 2 of those were at work. Close your eyes. Is it possible that this is sexual harassment? Okay, yes. Those who say no. All right. So I think there was only one of you who said no consistently, and you are the winner. Ding, 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 you found the right answer, at least with some cases in the American legal system. And so I think that these answers are counterintuitive. I was really glad to find out that Canadian audiences aren't very different than American audiences. So I've given this talk several times with American audiences, and I get sort of almost universally in each hypothetical, people are saying, yes, it's possible that was workplace discrimination. So the central premise of the book that Suja and I wrote is that courts don't adjudicate what we call traditional claims very well. So what the entire book looks at cases where there is actually evidence of some bias based on a protected class. These aren't unconscious bias cases in fairly traditional work environments. And we think that these are supposed to be the easy cases. But unfortunately, the American court system dismisses many of these cases. And so we're worried that as we move more into precarious work, as we move into sort of higher level questions like unconscious bias, that if we don't have a system that can't handle traditional claims very well, we have absolutely no hope to cover these more difficult questions. So let me tell you a little bit how American law works, and of course I won't have time to describe it in its entirety, and I'm happy to do so in the Q&A. But when you see a claim in the US legal system that's a discrimination claim, the courts have developed this very complicated framework for thinking about discrimination. So I teach an employment discrimination class that meets for 3 hours a week, and we are 3/4 of the way through the semester, and we have not finished yet describing the analytical structures that the courts use to evaluate discrimination claims. So we have this sort of name it and frame it mentality. The courts look at the types of facts in front of it, then they give it one of these names, and we won't have time to go through all of them. Then there is an analytical structure that applies to each of these kinds of discrimination. The courts apply the analytical structure, and then whatever answer comes out at the end tells us whether discrimination happens or not. Now, attached to these sorts of ideas, these labels, are corollary frameworks that the courts have developed, and I'm going to talk about 2 of them today. One doctrine is that what happened to you is not serious enough so that you don't need a remedy under federal law, and the second is called the stray remarks doctrine. So I'm going to give you a couple of more stories. Again, these aren't made up. These are actually based on actual cases that were filed in federal courts in the United States. I've just changed the name of the worker. So Henry worked in a workplace where coworkers routinely showed Confederate flags on their work boxes and their hats. The letters of the Ku Klux Klan, KKK, were scrawled throughout the workplace. The supervisors repeatedly called him boy and used racial epithets. And then there's lots of evidence that I can't repeat here, including one threat to kill him that was directly tied to his race. This case was dismissed by the court, and the reason is that all of these things weren't serious enough to merit federal protection. The courts use the doctrine severe or pervasive. Henry's story does not arise to that level. Helen, too, has a different story. She's a police officer She actually had a lot lengthier allegations than the ones I present here. A coworker tried to kiss her, stood on his tiptoes to look down her shirt, rubbed up against her, showed up in her driveway, sometimes drunk, and in one drunken episode told her son that he loved his mom, and said numerous things that I cannot repeat here. Helen's case too is dismissed. Why? It's not severe or pervasive enough to merit a remedy. So the hypothetical that I gave you at the beginning about Beth, that case too was dismissed. In fact, this is a very famous case in American jurisprudence. It's cited hundreds of times, largely by employers who are trying to get the courts to dismiss the case. And the way that the analysis goes is, hey, look at what happened to Beth. If this isn't serious enough to constitute discrimination, then what happened in my case isn't either, right? And this case has been used hundreds of times to allow other cases to be dismissed based on the precedent that this case sets. The secret memo, so I sent you an email that said that I was going to discriminate against you, that hypothetical was actually based on a hypothetical that the DC Court of Appeals used. Now, it made the email a secret email that wasn't supposed to get out, and the DC Circuit Court of Appeals held as a matter of law that if your supervisor said that you were going to get a negative evaluation because of your race and then you received one, that doesn't count. Why not? Negative evaluations, not serious enough to count and need a remedy under federal law. We see this then bleeding over into the retaliation cases. So this is the case we just talked about in my class last week. A worker was in the hallway, she was bent over, a supervisor who she did not know slapped her on the butt. She went to the Human Resources office to complain and then was fired, and the court dismissed her case. Why not? No reasonable woman would say that being slapped on the butt was sexual harassment, and therefore she can't sue for retaliation protection either. So we see sort of case after case with this doctrine and the stray remarks doctrine. This is another doctrine that the courts use. Basically what they do is if the comment or the conduct is considered to be merely a stray remark, it can be excluded from the evidence. It doesn't even count as part of the worker's case. Racial epithets are often dismissed. There was a case where the supervisor repeatedly referred to women using words like slut and whore. The court said this was not evidence of sex bias. Those were merely stray remarks by the supervisor. A case where black workers were told that they were lazy, worthless, and just here to get paid. Those comments didn't count. And then the hypo that we had at the beginning, you're too old for this kind of work. Also not probative evidence of discrimination, merely a stray remark. So I hate to leave on a depressing note. I'm happy to sort of talk about solutions in the question and answer period. But I think one of the things that the conference shows us today is that our workplace laws need to be a little bit more flexible, not only to deal with precarious work situations, but also to change with the changes that are happening in the substantive areas of workplace law. And at least from the United States view, we haven't gotten the traditional claims right, and so that makes me very nervous about what we're going to be able to do in the future. So thank you very much.
Years and 2 weeks ago, I arrived in Clinton Creek, Yukon, and the first thing I saw was a demonstration, strike, instant arbitration, call it what you will, by about 300 construction employees who were fed up with the quality of the food. They said, we don't work until you change caterers, and within 24 hours, one set of caterers were out, and a new set of caterers were in, serving fresh shrimp on the table in Clinton Creek, Yukon. That was my first experience with strikes under what I call the reality system. They had the power to strike. The employer had no power to stop them. The employer needed them to work, and so it complied. About 50 years ago this weekend, I was first elected a shop steward. Steelworkers, still proud of it. But my experience with labor relations perhaps comes from that starting point. I long ago moved into the neutral role to administer what I think is a system that has served well. About 20 years ago, I'm just giving you a quick survey of my life, and I'll leave out all my domestic relations. We'll be here all day. I was asked, I'm very privileged, to give the speech to the Canadian Industrial Relations Association celebrating the 50th anniversary of the Wartime Labor Relations Act. And I chose as my theme a doctor's analogy. How healthy is this Wagner Act system? And I said, you know, for an old guy of 50, looking back, 50 isn't an old guy anymore, I only wish, that it wasn't in bad shape for 50 years and could expect a number of years of active life. This time, building on the Fisher concept, I've decided to give an engineer's report on the state of Wagnerism, and I must say, from an engineering perspective, on the structural sufficiency of the Wagner Act model in Canada, I have grave doubts about its ability to serve for much longer without major renovation. I want to give a caveat to this audience, as I do regularly when speaking about industrial relations. Canada is not homogeneous. I get to travel, people say, where do you work? I say, you know, high level, high prairie, high river, all the high places. There are regional differences. There are differences between the industrial labor relations, which is stronger in Ontario, construction and maintenance, which is stronger in Alberta, and the public sector, which has a whole set of its own rules and concerns. Behind all the questions about unionization, there is at play the reputation of unions as useful elements in our society. And I agree completely with Harry Arthurs that, like taxes, unions have somewhat come into disrepute. And that is not by accident, but an organized campaign. When we're talking about the contrast between secure work and precarious work, I also want to add one other element of lack of homogeneity. And that is, many people's work is not only precarious, but it is multi-employer. I think one of the biggest challenges is for the poor person who tries to jockey 3 precarious jobs rather than 1. And I don't think we're paying quite enough attention to their particular interests. Let me go to the foundations. Wagnerism. The Wagner Act, we forget, was born out of fear. Fear created by revolutions in Europe and fear of a return to the economic state of the Depression, and before that, the steel, auto, railway strikes that involved considerable violence. There was a deal cut out of fear because both sides had an advantage. The deal gave labor certain advantages. The duty to bargain in good faith, certification by a vote system. But at the other side, it took away from labor that ability exercised by those construction workers in Clinton Creek. It said it is illegal to strike except in this very narrow quantum burst system that we set up. And I question whether we have not forgotten how to exercise power. And in all the debates I hear about precarious workers, and this conference has been typical of that, I haven't heard much about strikes by precarious workers, organizing by precarious workers, or using Sololinsky tactics or the new tactics that are allowed by social media. The truth is, people, institutions, governments, and corporations do not move unless they are afraid of something if they don't. And I think we need to seriously think whether the restraints of Wagnerism are worth the price. I want to move ahead to the 70s, because I think a profound change took place in both the 70s and again in the 80s and 90s. We moved to a rights concept of labor law. It was power. You have the ability to negotiate, but if you want to get a result, you have to exercise that power. But in the 70s, we started getting queasy about people who chose not to organize and tried to raise their standards. All worthy, but we got to the point where we put a tribunal in every pot. We had human rights tribunals. We introduced occupational health and safety tribunals, employment equity tribunals. And we tried to solve many of these problems after the fact with judicial processes. All worthy, and I'm not critical of them, but it added an overhead, a burden, and I think it is reasonable now to say, how's it work for you so far? And from what I hear today, the answer is, in many cases, it hasn't. We also had the emergence of the Charter of Rights and Freedoms. That put in the minds of many people the notion that these entitlements are already there rather than having to be fought for. I believe in the rights in the Charter of Rights and Freedoms. When I sit down with construction workers in Fort McMurray or pulp mill workers in Hinton, I am less sure of their commitment to your vision of the legal reach of those fundamental rights. They still have many of the prejudices that existed before that. Then we had the advent of computers that allowed employers to subcontract work, to subdivide work in the way that was so eloquently described last night. Until, this is talking of the fundamentals, until Harry stole my line, hey, fracking's Alberta, eh? Don't you go stealing my fracking. I was going to say the foundations of labor relations are subject to fracking. And I'll name names. It's the Fraser Institute, it's the Koch brothers. The amount of money that has gone into undermining collectivism, supporting concepts like right to work, a peculiar phrase, merit shop, an equally peculiar phrase, has a vast impact on the public impression of unions. And this is deliberate, and it is paid for in not millions of dollars, but tens of millions of dollars, even in a small jurisdiction like Alberta. How are building blocks doing? Well, employers we heard about last night. There's nothing left but the grin on the cat. They have managed to morph, subdivide themselves horizontally and vertically. We see in the construction industry in Alberta, an employer can change overnight, and the employee hardly ever knows who they're working for. Other places are more stable. As I say, it's not homogeneous. Unions. There's lots of discussion about what unions can do, but I'm reminded of that great saying by that rogue Archbishop Marcinkus of the Vatican. He said, you can't run the Vatican on Hail Marys, and you can't run a union on singing solidarity. If a union is to serve a role in society, as we realized in Canada when we essentially legalized RAND formula, the union has to have a revenue stream that enables it to pay for the services it provides, and they are expensive. And we have made them more expensive. And if we talk about unions morphing into a new role, we need to keep an eye on the revenue stream. I'm not being callous here, it's just a reality. You can't run the Vatican on Hail Marys. Unions today, particularly with the advent of the rights age in the 70s and with the Charter, run the same problem that political parties today run. One of the best analyses of that I've ever read is by an author, a historian named Tony Jute, unfortunately passed away recently. But he said one of the great breakdowns in society is that political parties no longer have the facility to broker compromises between the various interest groups that make them up. And I believe unions are beginning to suffer from the same thing. And just a few examples from my own experience. I remember when bus drivers were all men and they said they couldn't be women because they wouldn't fit the uniform, as if the haberdasher had never seen a pair of breasts. I fought through the accommodation, the duty to accommodate. There are huge tensions within unions dealing with the senior person who feels entitled to a job and the disabled person who is entitled to an accommodation. Brokering that puts a strain on a union. They do it very well, but don't underestimate the support cost and the legal fee costs for doing that. I've been involved in the Indigenous workers versus the building trades hiring hall when we've tried to introduce Indigenous workers into the oil sands projects. And the problem with contract workers versus employees who have tenure. And deliberately earlier on, I tried to throw a stink bomb into the debate between contingent university teachers and full-time academics, which is a legitimate debate. Shut up in 2 minutes? Okay. I want to make one more point. We've heard a lot about how you resolve disputes. A friend of mine said once, let the forum fit the fuss. We are spending vastly too much, and unions and employers are spending vastly too much on heavily due process-oriented legal solutions to workplace problems. We have disenfranchised a lot of managers and shop stewards in favor of Supreme Court of Canada or Supreme Court of the US cases. And I see money being spent on these cases, which, if allocated at the beginning, could have made everybody happy and had a good party too. And I just raise that as to whether we haven't made the practical Wagner Act compromise into a vastly expensive legal solution and abandoned some of the on-the-ground practicalities of the system. And now I'll shut up. It's 2 minutes up.
Thank you very much, Michael, for inviting me here, and thank you to Western and Koskies for hosting this. I'm going to try and tie together some of the themes that have come out both from Sandra's and Andy's presentations, because I want to talk about broader-based bargaining. How do we actually get, how do we secure labor rights in this fissured workplace? And I do think that it is important to be able to have collective action, to have real meaningful collective action, but that doesn't happen in a void. And so I want to get a little bit granular about what precarity looks like on the ground and how there is a really deep mismatch between the system that we have and the people who need its protection. What I want to focus on is broader-based bargaining specifically for precarious workers in the home-based care sector, and so that picks up on some of the issues of discrimination that Sandra was raising and that we heard earlier this morning. When we're dealing with workers in the home-based care sector, we're dealing with really strong ideologies about the family. We're dealing with very strong ideologies about what counts as work, and as we've heard, women's work doesn't count as work, and roles, the role of law in that. But, you know, again, so in this sector, work means deeply gendered work done by women. It's also work that's done overwhelmingly by racialized women, and increasingly by women with precarious migrant status. But instead of it being a nice, neat pie like that, it's more jumbled like this. All those layers and intersecting and compounding forms of precarity are then moved into a structure of work that is itself deeply fractured. Also, what's fractured is that we have completely separate silos of policy development. We have, at the federal level, policies around temporary labor migration, which create very deep insecurities. They construct the insecurity that we see. That policy development happens in that silo. And in Ontario, we've had two different big policy initiatives. One, the Changing Workplaces Review, that looked at labor and employment law. But then in a completely separate corner, conducted by other people, we've had the gender wage gap strategy, as if those were somehow alien to each other. All three of those are obviously implicated here. And this entire thing operates on top of our political economy, which we have to remember that, you know, as Harry said this morning, what we see is entirely the product of decisions that have been made, deliberate decisions to create the outcomes that we have. Nothing that we see is accidental. I'd remind you that in the 35 years now, since the Charter was introduced, we've had 223 pieces of legislation that have restricted rights to collective bargaining. This is in the age of the Charter. So we have, of course, seen a decline in unions. We've had decades and decades of austerity programs, a persistent failure of federal and provincial government to adopt policies to support accessible, affordable public child care, elder care, and care for people with disabilities. And that has driven an enduring reality in which significant socially necessary work, caregiving labor, is being driven back into the homes instead of in the public sphere. So we've got austerity, we've got the increasing demand for flexibility, we've got the persistent undervaluing of care, and as Leo was saying in her presentation this morning, you see that by the carving out of home-based caregivers from even something as simple as minimum standards, right? And of course it produces a growing income inequality. So we've got, and all of that together creates a very gendered and racialized experience of a pay gap and workplace precarity. The sectors that are that I'm looking at in terms of the home-based care work are child care, health care, elder care, and care for people with disabilities. Many years ago, now it's kind of embarrassing how long ago this is, when I was starting out in law, I was part of a project looking at how do we build security for vulnerable workers. There's a project looking at how do you meet the needs of vulnerable workers in a context of subcontracting and creation of precarious work. And what we stated then is that a legislative strategy that seeks to promote decent work and working conditions for workers in these sectors can only succeed if it addresses the structural basis for this profound inequality in bargaining power. So what do the employment relationships look like? What does it actually look like? There's a multiplicity of different kinds of employment relationships in these care sectors, and this is similar across all those 4 care sectors that I've talked about. There is publicly funded care that is received through an institutional facility. In some cases, like for healthcare, that will be for a limited amount of time. But the workers in that facility can be full-time, part-time, permanent, casual, or agency workers. So even in that traditional core workplace, the labor force itself is completely divided into tiers of precarity. There are caregivers who are employed by agencies. There's caregivers who are hired directly by families. There's caregivers who work as independent business people or independent dependent contractors. And so you've got this mix of direct employment relationships, but also triangular relationships where there's labor brokers and intermediaries involved. But then what does it look like from the worker's perspective? It's a mess, frankly. The reality of multiple job holding that Andy talked about is absolutely standard. And there is not just multiple job holding, but multiple different kinds of relationships simultaneously. So an individual worker may have some hours in an institutional setting, but then may have to piece together a few hours here, a few hours there, through agency work, through direct hire, through caring for multiple families in multiple locations. And so an individual worker may have a number of experiences of different statuses of employment. They may be working permanent part-time for some agencies, casual with others. They may have, and I know so many caregivers who do, who have a full-time job and another equivalent of full-time hours piecing together other work, because the wages they receive are not sufficient to live on, because this is one of the lowest paid sectors of the economy. There's a lot of workers who are essentially working piecework, and they are funded for 25 minutes of care for a particular client, and regardless of how long it takes to actually deliver humane care to an individual, they're only funded for those 25 minutes. They're not funded for the time that they travel in between clients. Right? So it is tremendously a tremendously fissured employment structure, and also the fragmented work that individual workers are doing. And you add on to that the experience of migrant workers who are increasingly not just being employed to work in individual homes, but also in institutional settings. The migrant caregiver program initially started exclusively dealing with childcare, and as austerity programs to deinstitutionalize and privatize elder care and care for people with disabilities, the mandate of the temporary foreign worker programs expanded in lockstep, so that workers were doing a broader range of work, and now they are doing them in a broader range of places. And more forms of core health care are similarly being brought into the temporary foreign worker program, where workers are subject to predatory recruitment practices and are on tied work permits, which mean they can only work for the individual employer named on their permits. So what are the structural barriers to decent work? We've got, actually, you know what, this is well, let's see. We have a number of things that we've mentioned earlier, the statutory exclusions. The statutory restrictions that come through the temporary labor migration programs. You've got workers who are working in highly personalized relationships. So the capacity to do something like exercise the right to strike is very difficult, right? Never mind the fact of precarious employment status, which means that that's not an option to begin with. It is an area of work that is deeply imbued with discriminatory ideologies around race and gender. The complexity of the employment relationships, the fragmented and precarious work rhythms that make it really just difficult for people to live humane lives where they have space to be able to do anything other than get from one place to the other and cobble together enough to pay the rent and get food on the table. And there's a deep lack of proactive standards enforcement in the area. I'm missing a couple of slides, sorry. I've got an old set of slides here. But the one that's supposed to come next says that freedom of association is a charter right. We know now that the Supreme Court of Canada has on numerous occasions identified that the right to join a union, the right to engage in collective bargaining, and the right to strike are all constitutionally protected. Beyond that, when there are sectors of work where it is difficult for workers to unionize, the Supreme Court has also recognized that the government has a proactive obligation to enact legislation to ensure that this fundamental right is accessible and meaningful in practice. And beyond that, the courts have recognized that the whole point of giving constitutional protection to freedom of association is to ensure that the deep power imbalance between employers and workers is brought into balance, that the disparity of power there is so deep that it drives completely predictably levels of exploitation that are socially unacceptable. And yet, every time we go to court, it's like we have to fight that fight all over again. And we have to remind our governments that yes, they really did mean it when they said that these are our constitutional rights. But the models that we have right now aren't sufficient to deal with that kind of fractured workplace and that kind of structure of work, which is very typical of women's work in fields of work that are predominantly female. This is more normal and has been for a long time. The report that I talked about at the beginning from back in 1993, I did that work with garment workers who were doing piecework in their homes and with migrant caregivers. And the demand at that time was to introduce legislative reform to have broader-based bargaining that addresses the reality of the dynamics in the sector. In the Changing Workplaces review, one of the things that they looked at is the fact that domestic servants, home-based caregivers, are still statutorily denied the right to unionize, right? That's the first step. We've got to get rid of that because this is, as we know, a constitutional right, and you can't actually exercise your collective action if doing so leaves you without any protection. But the Changing Workplaces review acknowledged that, or their position was that that's not really going to get people very far. What we need to do is to actually do some sectoral standards setting. One of the other barriers to unionizing, if you just take out that exclusion, is that you need to have a bargaining unit of more than one person. So it does require a deep rethink of how we imagine a structure that produces meaningful collective bargaining and balancing of power. A process of simply introducing sectoral standard setting is, in my view, not sufficient. It is not a remedy to this because it excludes what is the key element of collective action and representation, right? We've seen sectoral standard setting in the past being something that serves as a cap that suppresses wages, not as something that actually lifts the bottom. I will give you the example, as Leah did this morning, of agricultural workers, where the minimum standards have effectively been a cap that has carved that sector out as a no-right sector of work. So that was the recommendation. The Changing Workplaces review went further and said that it really is time to look at broader-based bargaining more deeply. They did make recommendations with respect to franchises and some limited sectors, but those are all premised on the ability of workers to access the system as it exists right now, and then just add on new locations. But we've got a sector that is almost impossible to organize because of the deep fracturing and the precarity of the people who are working in it. So I think that the days of tinkering are done, that we're at a point where it's absolutely necessary to be thinking those big ideas about how do you actually make this a meaningful right. And we have to think about the underlying reason why we care about all of this, which is the human toll that it takes. That we are creating a society of deeply impoverished, deeply precarious people who are suffering, and it is corrosive to our entire society. There are models of broader-based collective bargaining around the world that have been organized for workers in the home-based care industry. Happy to talk about some of those ideas. But we need to build power from the ground up, and there's some starts to it.
So the point of my rushing all of these stellar speakers was to hear what people here have to say, and for you give you an opportunity to both exchange thoughts and ask questions. So who'd like to start? Oh, come on, somebody must have the thought triggered by all of this stuff. Sure, go ahead.
This is a specific question for Sandra, and it's coming from, I guess, the perspective of the management side of it. And I must say, I think some of us have been back and forth quite shocked by your presentation. I think I would not like to be a lawyer showing up for our human rights department or a court with those fact situations. And indeed, I can think of a case maybe that deals with those fact situations specifically, and almost invariably, I think, an adjudicator faced with these facts in Ontario would say this is a very serious exception to that. So I guess my question is there in the States, is there a sign that change is going to happen with respect to the legal frameworks that are currently in place? In Canada, we've had, I don't want to paint Canada as perfect. We've certainly, over the course of the past 2 decades or so, collapsed what was quite complicated frameworks to look at adverse effect discrimination, direct discrimination, into a single unified framework that I think has been, and that's been a positive development. Is change on the horizon?
Go ahead.
All right, well, you make me happy that things here would be different. That's great. So I don't want to paint too uniform a picture. So there are circuit splits. So as you know, our federal courts are divided into circuits. And so in some of these circuits, the case would be allowed to go to a jury trial. But we saw enough sort of across circuit problems with cases that we felt we needed to write this book. There are certainly certain federal districts where it is much, much harder to litigate cases. A few things give me hope. One, if you talk to in-house or HR folks, they do not think these are the standards. So what's interesting about the law, and I talk to my students about this, is You might have a worse position in litigation as a plaintiff, but a pretty good position if you're talking to your HR representative or an in-house attorney. So in other words, what the human resources professionals think is illegal discrimination is often very different than how that case would get litigated. So on the state level, it's interesting. Most of the states have a comprehensive state statute. A lot of them, unfortunately, have chosen to follow federal law as a matter of course. So if there's a legal question that arises under the state statutes, many states have chosen to follow federal law, which means they're just piggybacking off of the cases that I talked about. Now, the federal law has become so fractured that recently there are a number of states, particularly Hawaii and Iowa, so strangely on two sort of opposite sides of the political spectrum, who have very blatantly decided that, at least as to some major questions, they are not going to follow federal law, and they've started to sort of make their own paths forward, at least in certain areas of discrimination law. Unfortunately, I think what this means for employers is that because the federal law has become so fractured and problematic, the state law is also fracturing, and so the legal landscape for an employer, it's harder to sort of figure out once a case gets in litigation with all of those multiple legal systems, sort of where the case is going to end up. So there have been a lot of moves, I think, from the scholars to try to fix some of these problems, but we really don't see any movement in the federal courts yet to do that.
David?
Comment and expression, I guess, for Fay. And I'm going to cite one of the only cases in this conference so far where the United States might be more progressive than Canada. And that is during the Obama administration, one of the regulations my agency promulgated was covering home care workers under the Fair Labor Standards Act. And of course, our regulation was challenged all the way up to the Supreme Court, but it was ultimately upheld to expand coverage to about 2 million home care workers, to just give them basic rights for minimum wage and overtime. And then the subsequent rollout and implementation was incredibly complicated. And I would just cite two things to put this as a question. The very positive thing was during both the litigation and preparing for the implementation, we've heard endless stories about how this is going to completely undermine the provision of care, of home care, and how paying workers minimum wage and overtime is that antithetical to quality care. And our argument was no, in fact, quite aligned with that. The turnover, you get better workforce, you get better workforce, even though it was very fissured in lots of different ways. And the reality is often happens in labor regulation. Once they've had to do it, software systems, different systems to manage people's time, the issue of who pays for time of travel between two clients of separate payers, all of that messy stuff. What do you do about people who have 24-hour care? Insoluble problem. Well, in fact, there's a whole body of experience of how you deal with that, and as often happens, people kind of figure out how to make this happen. So that's the positive story, addressing at least part of the challenges you described. The downside is the pricing side, which is a lot of these services in the United States are covered by Medicare, and the Medicare and the Medicaid system as well provide pricing for these services that are inadequate relative to the labor standards, the costs are provided. So that's the tension that certainly exists out there. I cite this as a question about why not more attention. You're focusing more on, and I certainly agree as well, that you want to have these people able to be organized and using that form of regulation as a way to address some of these issues. But this more fundamental question of simply coverage under employment standards as a first, and in the United States, I think it's had very positive impact on police moving somewhat forward.
I'm not in any way opposed to employment standards legislation that provides a robust floor of rights. I think that that's a necessary thing for
across the entire labor market, is to have a real floor of rights that is robust, from which people can then exercise their collective rights. The difficulty is that they've been presented for this sector as an either, not even or. It's like, maybe we'll get to that. And one of the next phases that's coming up in our review of employment standards is to address some of the exemptions from it. But that point of addressing exemptions is where we're going to get that fight of the sky will fall. And what lies beneath it is a deliberate policy choice to not fund the system at the level that's required to deliver the care, but to then obscure the decisions that have been made to produce this precarious system. I don't think that we need to make a choice, right? I don't think that employment standards is a bad thing, but I do think that the failure to provide real meaningful protection for collective action does a real disservice to the workers. Workers are not themselves vulnerable, right? Inherently vulnerable. They are made so through the way that law marginalizes them. And in a system where there's no protection for non-unionized workers to exercise collective action, and no real capacity for them to organize collectively, even though that is what they want, having simply a minimum standard system keeps them marginalized.
Could I add one comment to this debate on marginalized women particularly? But that is, under the system we have now, without any adequate employer funding of daycare or social funding of daycare, the revenue is coming from the same marginalized women who are in the position of jockeying 3 jobs and trying to pay for the other marginalized worker who is looking after their parents or their children. So there's a bit of a vicious circle here, and my emphasis on funding is that, while I agree with all these things, until that funding is in place, it's just going to be chasing your tail. And I really commend the work of the CLC for trying to have universal coverage for things like daycare, farmer care, and so on, because I think that's the only solution. If there's no money, all the bargaining rights in the world don't take you anywhere.
I work as an organizer for steelworkers, and get my, I used to be represented, I went to school there, and then got a chance to come back 10 years later as an organizer and help organize all the administrative staff. So there's,
It's called revenge.
wait, just that one bad market. So a question to all panelists, maybe more germane to the Canadians on the panel than anybody. In my own union work around consultations around changing workplace review and Bill 148, I think it's safe to say, if we think self-critically inside steelworkers, that we came kind of late. I think we wish that we had placed more emphasis early on in our thinking around the broader-based bargaining models and options. And so I guess I wanted to see if any of the panelists want to comment on, especially if you've got more experience working with, I won't ask the chair of the board or the chair of the panel, but if you maybe on the panel, maybe think about why it is that Canadian unions and the private sector have, I think, been slow. We have been slow to come around to putting resources and thought into this, and it's more easier for us to fall back on some of our more traditional touchstones. And so any questions you have on that, in the spirit of self-criticism, would be helpful.
I'm happy to address that, because I've been talking about this for almost, I don't know, too long, right? And part of it is that the demand for this, the place where the most consistent demand for broader-based bargaining has been coming from is from racialized women workers with precarious migrant status. This is a group that has been driving this issue for decades. And I certainly sat around tables with many of
my union friends and leaders who were going into those meetings, saying you've got to be backing broader-based bargaining. Even if you don't want it, there's all sorts of workers out there who need your voice backing the demands that we're making. And that was a long fight. And part of it was that unions had other priorities that they were focused on. So in that, how do you actually build solidarity? Over the course of the process, unions did start to support those demands, supported introducing protection like Section 7 in the National Labour Relations Act, so that there would be protection for collective action by non-union workers, and to have more openness to broader-based bargaining. But it is a matter of whose voices are marginalized within the labor movement itself has, I think, honestly been one of the issues.
Yeah, just add one observation on that. We certainly looked at sector-based bargaining in 1996. I think things have moved along an awful lot since then. But the most powerful lobby with the federal government, no matter which stripe, has been the bankers' opposition to unionization. And a lot of the discussion initially of sectoral bargaining was to allow rolling certification of banks by branches. But the concept also challenges a fundamental element of Wagnerism, and that is majority support. Because what you're really looking for is majority support by branch or area to roll into a bigger group. And we have no mechanisms for that. And counter to it, we have the Walmart phenomenons, where stores like that happily close down. And most banks can close a branch and open one 2 blocks away with no difficulty, and do so. It's been a very difficult debate, but it has been the focal point of organized employer opposition much more than any other proposal.
Well, let me just interject something in here and just to add another twist to this. With all due respect to my good friends, Messrs. Murray and Mitchell, it wasn't broader-based bargaining wasn't just something they thought up or just came up. Broader-based bargaining, for example, in the construction industry in Ontario, has existed first with accreditation systems since the early 70s, and on a provincial level since 1978. And the push, ironically enough, for broader-based bargaining, for that, and we're not talking necessarily about the acquisition of bargaining rights, we're talking about where those bargaining rights go when they are acquired. Broader-based bargaining's been in Ontario in the construction industry and now replicated in many provinces, including Alberta.
Most strongly in Alberta.
Since 1978, the opponents of, because I know it doesn't look it, but I was around then, the opponents to that kind of bargaining were the building trades unions, because the demand for it came from construction industry employers who were getting whipsawed and leapfrogged regularly, and that there were something like 300 area agreements, and they were the ones who were pushing, and the opposition came from the building trades unions, who now, if you went to them and said, "Oh, get rid of provincial bargaining," would kill you. So and like there, to be honest with you, even in, and I don't want to take it outside of the construction industry, notwithstanding I grew up doing building trades union work. If you even take it out of those structures where it existed outside of it. So, for example, I'm again old enough to remember when there were national meatpacking agreements, and quite frankly, having been involved in the losing side of a case, then it was labor boards that said, "Oh no, we're not going to make our jurisdiction extra provincial. You're just confined to here, and if you're bargaining to break up the national meat agreement, we don't care. You can force that here." So that there are lots of impediments to it, but it isn't new. It isn't as daring. It isn't, we're all not going to be Swedes tomorrow if there's broader,
Or maybe turnips.
or Germans if there's broader-based bargaining in some areas in this country.
If I could just pick up on the meatpacking example, I could give you the same examples coming out of the printing industry. The rogue in that was the British Privy Council, who said your labor relations are provincially specific. And I don't think we should underestimate the importance of ideological differences in setting labor legislation across the country. There's been a great deal of pendular legislation. We're going to vote that out because they voted it in. Ontario's been bad at that. Saskatchewan's worse. BC, I suspect, will give us another example shortly.
Yes, I would like to turn the conversation. I wish I remembered this woman's name. She presented this fabulous piece at a recent conference I was at, and she basically went out and talked to a bunch of Uber drivers. And she asked them, how do you want to be classified? Do you want to be a worker or do you want to be an independent contractor? And what was really interesting about what she found is about half of them said that part of their value as a human being was in that independent contractor status. They liked what that denoted for their autonomy and sort of personal self-value. And so I think, part of the issue here is not only the governmental hurdles, which have been discussed before. In the United States, we've certainly had problems with these in the franchise or context and also with graduate students and things like that. But it's in convincing workers what being an independent contractor means, what they're losing by retaining that status.
So if I can just pick up on that, I think that it really does also come back to the kind of campaign on narrative that we've been subjected to for so many decades around you are brand you, that you are your career, that we've been indoctrinated into thinking that we can't expect loyalty and we can't expect there to be a job. And I think that is one of the things that we have to overcome, because there has been a very concerted attempt to break those ties and ways of thinking about collectivity.
Do you think that extends to not expecting solidarity or collaboration with your coworkers? You're sort of talking about not loyalty from the employer side, but what do those same people think about their colleagues?
I think that level of fear is very deliberately created and nurtured, so that you have your core of workers and then your much larger pool of contingent workers who are competing to maybe get one of the rare, right? Like the way in which employers have calibrated exactly what the balance is between core and contingent workers, so that the contingent workers don't rise up, right? There's, I think that we can't think that these things are happening accidentally, and need to challenge those broader discourses as well.
So, one more question, but that I can't resist. What you need to overcome is that notion that even though the odds are all against you, when you buy that lottery ticket, you're going to be the guy who wins that lottery. And that's really what, no disrespect to my American friends here, what the American dream's all about. Go ahead.
Mm-hmm.
I also have to say to this whole topic, we talked about security, we have 12,000 officers in community colleges. Right now, a lot of it is about security, trying to fight security. And one of the responses that we hear from students is, why don't we just suck it up? This is what the job market's like. Why are we doing that stuff? To try to protect the community. In a lot of the cases, the students, they don't know if you're getting a professor, or if you're grasping whatever higher use. But this is what we're used to. It's the same problem with sexual harassment. We know that there's a huge problem in Canada with sexual harassment. How do we fight the normalization to try to get them
I think that expect more. And I don't mean that I'm not saying that to be glib. I think that it's a conversation that we need to be having. And when we look at the way that the growing income gap has actually created that space to have a public discussion about, is this really the society that we want? It does create the space to expect more, demand more. That when we talk about wanting decent work, instead of focusing on precarity, saying what it is we want. We want decent work for decent lives, right? It changes the conversation. And I think that we need to be, in these analyses, being conscious of who's pushing the discussion to normalize, because it does actually benefit people, certain people. And so much of the discussion about precarity is focused on the experience of workers, not on the conduct of employers and states, which creates the precarity at the outcome, right? So we're looking at that outcome as if there isn't something acting behind it that produces it, and we need to shift the spotlight and make that conduct socially unacceptable.
Got a hammer?
We're talking about the college strike right now, and they make a point about changing the shift to look like the workers' issues are. And that's not enough, that's what we're talking about. But what about looking at what the customers' issues are? And the speaker just said what the students are saying. The students are saying, suck it up, this is what they're voting in the college issue. The college's enrollment is going up like this.
Yep.
It's going up because it's giving students what they want. And it's giving students what they want because they're flexible. They're able to change programs quickly, institute programs quickly. And these employment situations are part of that. University enrollment in Canada is going down like this. Universities are not flexible. And I can tell you, in some university conversations, universities are worried about it, and they should be. And so these situations arise not because anybody's trying to disadvantage people, but because institutions, or institutions like colleges, are trying to respond to what the students are asking for.
It's also, I mean, I happen to be in a bargaining unit of adjunct college professors who were on strike a couple of years ago, so I know this stuff quite intimately at a personal level. And I do, but it is a situation where in the broader context, it comes back to the funding of a system and that we can't treat as being closed, and thinking about what is it that we're actually trying to create with this system. If we create a system that is underfunded, then the response is going to be what we've got, which is that 75% of undergraduate courses are taught by contract faculty who who are earning like $40,000 or less with a PhD, right? That's a product of having an underfunded system. So how big a discussion do we want to have in terms of changing what we've got? If the kind of precarity we see is something that we want, then we've got the system that produces it. But if we don't want it, then we need to have a different conversation about the policy choices that we're making that drive it. And it just can't happen within that closed box.
I'm going to let you get the last word in.
So what I'm saying that even in the Canadian standard, the maximum minimum salary in Britain is 36, but by the national level, it's also salary is 48. So that's minimum is high. And we have been asked to the salary, so that's from 1,000 to 1,000. So we have to high now how to get it. And other question is the Untitled Labour Relations Act or regulation just as a solution for the common keeping the common. And there are, I am familiar to carry purpose and I believe that I needed knowledge of the legal stuff. And why does the legal or government system, like the regulation board of countries, is helping the people with limited knowledge of legal things? They are affiliated with national news, but sometimes they are also disagreeing with we are directly checking for culture, and we have disagreement with the national news. Our legal money remains with the national news. We don't have the legal. And that's like how the system is ensuring a level playing field. And because as far as I feel like board is really looking into narrow technicality. It is not looking into the intent of the law. It is really looking into narrow technicality, but we don't have legal knowledge. And other part of my question is, so individuals or locals may complain against the employer and the national union.
Sure where to unbundle.
I can jump in, actually. So this doesn't really answer your question, but I think it gives you another mechanism to think about how to answer it. So I'm lucky to have a number of colleagues at my institution who are involved in community action research. And so what that basically does is they have conferences like this one where half the people in the room are the people who are actually impacted by the questions that are being explored. And it does a number of things that are quite great. One, it starts to create different communities coming together. But two, it actually starts to inform the research questions that are formed in sort of interesting and unique ways. So I would highly encourage you to think about sort of networking and even using sort of this group as a springboard for starting some of those conversations.
Okay, well, I'm sorry we ran out of time. I want to thank all of these speakers. They were, like, at least for me, fascinating. I did not fall asleep, notwithstanding how much I ate at lunch. And I think the level of discussion, too bad I can't go on, was also wonderful. And thank you all. And I think it's a break.